with Kouri, we have been waiting to see what's going to happen with the sentencing. And we saw the defense arguing that there was a death in the family and that they needed more time and that one of the other attorneys, Mr. Ramos, is going to be in trial and. And then the prosecution came back with, girl. I mean, that's my summary of the prosecution's argument. That's not actually what was said, but my summary of the prosecution's argument was girl. I was curious to see what the reply would be when the prosecution was like, excuse me, Miss Ma'am, you really need this much more time? And what did I say when we were talking about that? What did I say? I said, well, the defense is asking for more time. The judge will probably give them more time. They're saying they need more time to get their witnesses together. They need more time for this and that. The judge will probably give them more time because judges often give grace in that way. And I am here to tell you today that I have never been more happy to be wrong. And we're going to look at what the judge had to say. I was very surprised that the defense didn't respond to the state's opposition because the state was like, so that trial's not really going and Ramos isn't really not ready. And the family has a right to a speedy sentencing as well. And the family is no longer going to sit by while we do all of this. I'm surprised that they didn't say anything at all. And we're just like, hey, Judge M, can we get a ruling on this? So let's see what Judge M has to say to the defense, shall we? Ruling in order denying defendant's motion to continue sentencing. The judge filed this yesterday afternoon. So it's Tuesday, April 28th. This was filed on April 27th in the afternoon in Utah. Before the court is defendant's motion to continue sentencing, docket 1727. On March 16th, 2026, at the conclusion of defendant's criminal trial, the jury returned guilty verdicts on all counts tried in the fourth amended information. Defendant waived her right to be sentenced within 45 days of the verdict. The court, with the agreement of all parties, set a sentencing hearing for May 13th, 2026. On April 13th, almost a month later, defendant moved to continue sentencing for two reasons. One, she needs more time to prepare mitigation information to support a sentence of 25 years to life instead of life without the possibility of parole on the aggravated murder charge. And two, one of defendant's three defense attorneys is scheduled to be in trial on May 13th. Notice he didn't mention anything else. Rule 22A of the Utah Rules of Criminal Procedure affords the defendant the opportunity to, quote, make a statement and present any information in mitigation of punishment at her sentencing hearing. This right exists concurrently with the rights of victims to, quote, a speedy disposition of the charges free from unwarranted delay caused by or at the behest of the defendant. Whoop, there it is. To facilitate a victim's rights, whenever a motion to continue a sentencing hearing is filed, the court is required to, quote, inquire into the circumstances requiring the delay and consider the interest of the victim of crime to a speedy disposition of the case. So what the judge is doing here, Judge M is acknowledging the shift. So prior to a conviction, so much of the focus is on the defendant's rights and the defendant's constitutional rights. The judge is acknowledging that there is room for a shift here, that after the conviction, there are also victims' rights at play that need to be considered. And those rights are codified in the rules of court. And we saw that in the prosecution's motion as well. The prosecution said, look, for years now, the victim's family has been at the mercy of the court process. When the defendant got new lawyers, everything got delayed a year. When the defendant wanted to appeal the lack of change of venue, this case got delayed another 8-9 months. Like, all of these delays have impact on the victim's family because they're constantly in this horrible holding pattern waiting for this case to go to trial. And now we have gotten past the guilt and those rights shift. The court goes on to say, defendant's motion does not present circumstances sufficient to justify a continuance of the sentencing hearing in this matter. The court granted defendant approximately 2 months to prepare for sentencing. Although defendant argues she needs additional time to prepare her mitigation case, defendant's motion lacks any specificity about what remains to be done or how long she expects preparations to take. Right. Y'all are just using conclusory statements. You're just saying we need more time. And the judge is like, what more time? What more time? What more time do you need? Although one of her attorneys experienced a death in her family, defendant has the benefit of 2 other highly qualified attorneys to gather and prepare mitigation information. Isn't that what we said? Judge M goes on to say, moreover, to the extent one of her attorneys is unable to attend the sentencing hearing due to commitments in another case, defendant has 2 other highly qualified attorneys who can represent her interests at the hearing. The court goes on to say, on the other hand, the victim's interest in moving forward without delay is compelling. This is just the court saying the prosecution made the better argument. In the unredacted version of the opposition memorandum, which is not the one we have, the state described in compelling detail the effect that a delay of the sentencing would have on the minor victims, which the court incorporates into this ruling by reference. So the court is saying that the things listed in the unsealed version of the prosecution's opposition is incorporated by reference, which is the way that the court is saying that I'm taking that into consideration, but I'm not putting it in the public docket. So the court's sidestepping putting it in the public docket by using that. There's points of the state's opposition that we've seen that are redacted and just lined out, and the court's incorporating those by reference. The court concludes the minor victims in particular, these are Eric Richins' children. I mean, yes, they're also Kouri's children, but she's lost parental rights and he didn't. He's deceased. The court goes on to say that the court concludes that the minor victims in particular would endure sufficient prejudice if the sentencing hearing is continued beyond its current setting. Accordingly, because defendant has not provided reasons sufficient to justify continuing the sentencing hearing, and because the victims have an interest in a speedy disposition of this case, defendant's motion is respectfully denied. To ensure that all interested parties have ample opportunity to be heard, the court has cleared its calendar on May 13th. The sentencing hearing in this matter is the only hearing scheduled before the judge that day. So the judge had set aside a half day for this and is now setting aside a full day. So I imagine the time of the hearing will be bumped earlier in the day. Kouri Richins told her family members, oh yeah, the sentencing date is the sentencing date for now, but I told Kathy Netzer to change it and she said she would. Well, Judge M isn't going along with that plan and said that the defendant's motion is long on excuses and short on actual facts, circumstances, and evidence. I mean, that's me paraphrasing a lot. But that there were no compelling reasons to continue the sentencing. And it looks like Kouri Richins is going forward to sentencing on May 13th. The court did acquiesce to a part of the defense request because the defense said in their motion to continue that they needed a full day to present the sentencing because they wanted to present witnesses and mitigation. If they show up with 0 witnesses and only argument, I am going to absolutely holler. But the court said, it's fair. I have cleared everything else from May 13th, and we're ready for a full day of sentencing hearing. So the only thing that's going to change about Kouri Richins' sentencing is it might start earlier in the morning. So Kouri is going to be sentenced on May 13th. The defense is going to get their full day for a sentencing hearing. We'll see if they show up with mitigation evidence, which can be statements from professionals, from family members. It can be letters presented to the court. It can be Kouri's own statement. And then I think on the 13th, we will see impact statements. And members of Eric's family have the right to make impact statements. The minor children have the right to make impact statements. I imagine that the children will not be there, and that if there are impact statements from the children or on behalf of the children, those will be submitted in writing. I do not expect that we will see them in court. I do not expect that we will see those statements made public, and I think that that's appropriate. I think that any statements of impact from the children, care providers, or professional providers should be sealed so that Kouri will see it. Her defense attorneys will see it. The court will see it. But I don't think that's for the public, and I think that that's fair. They are minor children. And so I think that it's going to be an emotionally difficult day for sentencing. I think there's a very good chance that the court does sentence her to life without the possibility of parole. I will be surprised if she gets 25 to life. That's just where I'm at. I don't know Judge M. I've not seen Judge M sentence on other cases. I think that when you are looking at the circumstances surrounding this case, the attempted murder, then the murder, you are not looking at a heat of the moment type of split decision that somebody then regrets. You are not looking at an accident. You are looking at premeditation, contemplation, planning, and a level of cold, calculated murder that I think, and again, my perspective is coming from a former prosecutor, I think is in the category of life without the possibility of parole. This is a domestic violence related homicide, and it's very clear the ripples of damage that Kouri Richins has done well beyond herself. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.